What would be your sort of top 3 reasons for refusing access to documents, or would that just depend on the institution?
To whom are you addressing the question?
I suppose to Bart and Marc.
Okay.
Be at that level, yeah.
I have before me the Council Annual Report on Access to Documents, which is produced every year. It's also a requirement under the regulation. It's downloadable from our website, the Council's website, and it gives all sorts of statistics. One of the main, the 2 sort of like most used exceptions in the Council are international relations and defense. And this is it's a bit because of the role of the Council. You know, on the one hand, the Council is an institution that is a co-legislator, but a lot of the legislative documents are frankly upon production made available on the website. So we don't get requests for access. We don't get to the stage. They're made public. They're on the website. And you can download them there. So nobody asks for them. They download them. So that means that as a result of that tendency of the legislative documents becoming more and more public, the other part of what the Council does, and that is its role in external relations and defense on one hand, and in justice and home affairs issues. I'll give you an example, documents relating to fight against terrorism, that sort of thing, have been very much asked for by NGOs, typically NGOs, sometimes academic people. We had one client who was a convicted German terrorist, the Rote Armee-Fraktion, who's always asks for, I don't know whether he still does it, but for years asked for documents, and they always had to send him back on paper because he didn't have internet in his prison cell and such. But but that is a bit the result, more or less, by default, because the legislative documents are to a very large extent released, not all of them, mind you, and indeed there's one court case going on, as was mentioned, on the review of the access to documents regulation itself, or justice and home affairs, that is public security is then the exception. So public security is one which is used relatively much in the Council, of all the exceptions. International relations and defense. I think also protection of the decision-making process is used, but that is in the vast majority of cases we would give partial access then. And typically if we haven't taken a decision in a file yet, in most cases we can give out kind of the positions of member states, but we will not give out the identity of the member state. And it's a compromise to ensure that member states still have some freedom of backing down on positions, which is, you know, remember the Council has this sort of diplomatic sort of culture, which we are, it is an institution made up of member states, governments, and it's often extremely useful if a member state has a chance to be backing down without having to kind of gone public on its position first and then have to publicly back down, which is much more difficult. So that is why we often find a compromise in giving out a position of all the member states, but not saying which member states had what position. And then it depends a bit then on the precise scenario. You know, if you're speaking about fisheries, then often you know that it's not the Czech Republic that was very forward. But see, so you know, if it's about olives, then very often Sweden will not be very. So
as opposed to Finland.
As opposed to Finland. So that is. So that is not. You know, it's not a rule which is so set in stone that we can't possibly deviate in either way, but that is very often the solution chosen. So Article 4.3, first paragraph, if you want, of the regulation, the protection of the decision-making process. Once in a legislative procedure, or for that matter, any decision-making procedure in the Council, once a decision has been taken,
Yes.
The exception to protect the decision-making process 431 lapses. And if it's a legislative procedure, then those documents are put on the internet integrally, so with the names of the with the footnotes and such. And that's even predates Turco. That has been our practice for, well, before Turco. Turco didn't change that. So that is in our rules of procedure of the Council, Annex 2, for the diehards who want to check it out.
Yes, but regarding the Commission, it's quite different, because the Council uses very many of these mandatory exceptions on Article 4.1, but the Commission is rather the second, the discretionary exception. Number one is the protection of investigations, which is used to protect ongoing infringement proceedings. Quite a number of them, thousands of infringement proceedings going on year by year, and also in competition cases, merger cases, state aid cases, antitrust, anti-dumping cases. So these are just the main exception. Another exception which is frequently used is also the protection of commercial interest of companies, because the Commission holds a lot of company information. For example, in competition policy, obviously, a lot of information has been either provided by companies or it has been seized on the premises to an inspection. A particular reason for not disclosing information is in cartel cases. Many cartels can only be unveiled if there is a whistleblower. So the Commission has a so-called leniency scheme, which means that a company participating in a cartel, which comes forward and gives information to the Commission, which enables the Commission to prove that there was a cartel, will have a reduced fine or complete immunity from the fine due to the fact that it's cooperated, this kind of whistleblower scheme. So if you would expose a company that has come forward and provide information to the Commission to unveil a cartel, in disclosing information that's commercially sensitive and that could be incriminatory to the company in, for example, further damage cases, because the reason why law firms want to have access to these files of the Commission is that they want to use some of the information that the Commission holds on companies in order to feed claims for damages at national level to national courts. And so this is one of the main reasons for the Commission. The Commission also sometimes uses the decision-making process exception, Article 4.3, basically to protect internal deliberations which precede the decision-making. The minutes of the Commission's meetings are public. They are put on the website. However, before the Commission decides, there are meetings at the level of the civil servants preparing the drafts, and then there was a political meeting of the members of the cabinets of the commissioners meet before the commissioners meet on Wednesday. The heads of cabinet meet. So there are documents reflecting the internal debates, and these documents are normally not disclosed in order to safeguard the collegial decision making, because normally the Commission takes almost all its decisions by consensus. The Commission hardly ever votes. It's not like a Council of Ministers. There's hardly any vote. But before that, there's a lot of debate between the different departments. And you can imagine that, for example, in certain legislation, the Department on Environment does not share the views of the Department of Industry. So these debates are also sometimes a reason to be protected. And then, I mean, it's less used, but also international relations is used by the Commission because the Commission has the exclusive ability to negotiate trade agreements with third countries. The Commission has a mandate from the Council and then negotiates trade agreements on behalf of the Union, and then during ongoing negotiations we sometimes receive requests for access to the negotiating papers, and of course if you would disclose that, even the negotiating mandate given by the Council or the position papers that are being used, that could damage the Commission's position as a negotiator vis-à-vis South Korea or China or countries which are not as transparent necessarily as sometimes the EU institutions are. So this is also a reason for not disclosing access. Personal data has been mentioned as a problem area, but it doesn't really, I mean, there are not so many cases where the data protection is at stake. But when we have such cases, they may be problematic. And then the specific problem for the Commission, rather for the Council, is the documents originating from member states, because in an infringement proceeding or state aid procedure, the Commission has an exchange of correspondence with a member state. The Commission's policy is not to disclose documents on pending cases, but to disclose documents when the case is closed. So the Commission would itself disclose its own documents, but some member states are reluctant to have their replies to the Commission's request for information disclosed even after the case is closed. And there is one case pending in court where the Commission did overrule the position taken, the refusal by the German authorities to disclose their replies to a letter of formal notice and reasoned opinion in a closed infringement case. And the German authorities have taken the Commission to the courts. So this may lead to some clarification in how you have to assess the objections made by a member state against disclosure of its documents. And there is a difference of culture among member states. Some member states are rather open. I don't have to mention the member states that are the usual and the more transparent countries, and some are quite reluctant to disclose documents, even in closed cases. So this is a problem because we have to reconcile different traditions, and we have to fit them into this single framework of this regulation.